Welcome to the first Salon in the Transnational Justice Project's Critical International Law Salon series. The theme of today's conversation is justice, law, and structural inequality. This conversation in the Salon series engages with themes that we will explore in more detail in the inaugural Critical International Law Summer School, which will be held in July of 2022 in Rwanda. The summer school is open to advanced students in the social sciences and law, and it will bring together faculty from academic institutions around the world to engage, debate, and collaborate on topics related to critical international law. More information about the school is available at Transnational Justice Project, and the link is there on the YouTube channel. Today's conversation considers the relationships between justice and law and how they create, deepen, or mitigate structural inequality. One of the things that the COVID-19 pandemic has laid bare are the deep structural inequalities that exist in our world and the way that they are connected to everyday practices. Yet international law in general, and international criminal law in particular, have faced challenges in addressing these inequalities. It seems that these legal forms have also struggled to address the related racial politics that are extensions of such forms of inequality. This panel will reflect on various approaches to justice, the extent to which law and justice are intertwined, and how they are related to other mechanisms. So a few points before I introduce our panelists. The format today invites our guests to integrate their research and expertise in a candid conversation among colleagues. This will be followed by a discussion with questions from the audience. So please feel free to use the comment section to pose questions and indicate whether you're posing the question to a specific guest. A recording of this webinar will be available on the International Summer School Salon page shortly after the event concludes today. So I'll now briefly introduce our guests before we start off the discussion. Today, we're joined by three scholars whose work has been influential in addressing the relationships between law, justice, and structural inequality. We have with us Kamari Clark from the University of Toronto in Canada, Jill Stauffer from Haverford College in the United States, and Christopher Gevers from the University of Kwazulu-Natal in South Africa. Kamari Maxine Clark is a distinguished professor of transnational justice and socio-legal studies at the University of Toronto, at the Center for Criminology and the Center for Diaspora and Transnational Studies. She is also an adjunct professor at the University of California, Los Angeles, and a faculty fellow at its Promise Institute for Human Rights. For more than 20 years, Professor Clark has conducted research on issues related to legal institutions, international legal domains, religious nationalism, and the politics of globalization and race. She has spent her career exploring theoretical questions of culture and power, and in the field of law and anthropology, detailing the relationship between new transnational formations and contemporary problems. She is the author of 9 books and over 50 peer-reviewed articles and book chapters, including her 2009 publication, Fictions of Justice, the International Criminal Court, and the Challenge of Legal Pluralism in Sub-Saharan Africa, with Cambridge University Press, as well as her more recent book, Affective Justice, with Duke University Press, which was awarded book prizes from the American Anthropological Association and the Royal Anthropological Institute. During her academic career, she has held many prestigious fellowships, grants, and awards, including multiple grant awards from the National Science Foundation, the Social Sciences, and the Humanities Research Council of Canada, the Rockefeller Foundation, the Wenner-Gren Foundation for Anthropological Research, and most recently, the 2021 Guggenheim Prize for Anthropology. Jill Stauffer is an associate professor and the director of the concentration in Peace, Justice, and Human Rights at Haverford College. She's on the editorial board for the nonprofit book series, Voice of Witness, which illuminates human rights crises through the stories of the people who lived through them. Her academic interests include philosophy of law, political philosophy, continental philosophy, and ethics. She has published articles on practices of hearing that succeed or fail, legal and political responsibility, political reconciliation, child soldiers, settler colonial silences, and the rule of law. Her edited volume, Nietzsche and Levinas, After the Death of a Certain God, was published by Columbia University Press in 2009. Her book, Ethical Loneliness, The Injustice of Not Being Heard, was published by Columbia University Press in 2015. And she's currently working on a book called Temporal Privilege, Interruption and Resistance in International Law in the Settler Colonial State. Finally, Christopher Gevers teaches international law and legal theory in the School of Law at the University of Kwazulu-Natal. His research focuses on histories of Black internationalism, third world approaches to international law, critical race theory, and law and literature. Since 2015, he has been a faculty member of the Institute for Global Law and Policy at Harvard Law School, with visiting fellowships at the University of Oxford and Harvard. At present, he is co-convening an interdisciplinary project on literature and international law at the Edge, with Joseph Slaughter of Columbia University, Vasuki Nasaya at New York University, and Gary Simpson at the London School of Economics and Political Science. His most recent publications appear in the UCLA Law Review and the Oxford Handbook of International Criminal Law. And I'm Sarah Kendall, reader of international law at the University of Kent in the United Kingdom. Welcome to our event. This event announcement frames the theme of justice, law, and structural inequality in relation to our present context, where COVID-19 has laid bare the relationships between structural injustice and everyday practices. We might think in particular about how forms of inequality and structural racism have appeared prominently against the backdrop of the global pandemic. Christopher Gevers, you recently wrote that there's nothing international law can do to alleviate suffering in the midst of the pandemic. So I'd like to start off from this provocation by asking each of you to address the present pandemic context in light of the challenges it poses to international law. And we'll start with Kamari Clark.
Okay, thank you, Sarah, and it's wonderful to be here and to be amongst some of my favorite scholars and interlocutors. So great to be here. It's fitting that we're starting with the pandemic in many ways, where we are at the moment, the great inequalities around access to the vaccine, but also, and as you've said, Sarah, quite eloquently and overtly, the pandemic has in many ways highlighted for us the nature of structural inequality. For many of us, it's business as usual. We've seen this. It isn't new. For others, it really did open up a sphere for thinking about the way that structural inequality permeates everyday life. Perhaps what I'll just start, I guess, by way of reflection is to think about, and in the spirit of Christopher's comment about the inept nature of international law to attend to structural inequality, here, I'm speaking from Toronto, and the politics of residential schools and the death of so many young people who were taken from their homes and from residences and enrolled in residential schools is a sobering, or at least the reflection of that is sobering for us. The decimation of Indigenous peoples on this land, the extent to which we're seeing continuing, in many ways we could even say continuing crimes, certainly the continuation of settler colonialism and the implications, the ways that it embeds everyday life. And often those forms of everyday life are quite normal. They're normalized in our everyday world. And this pandemic in many ways is deeply aligned with both the kind of public engagement and fury around settler colonialism and indigeneity, and the silences that have kept that story not part of the public debate. But it's also aligned with white supremacy and structural inequality around race and racism, police brutality, as we've seen over the years as a result of the visual technology and the death of George Floyd, and a whole range of structural challenges that are upon us, poverty, the great disparity between those who are at home, safe, working from home, online, via Zoom, and those who are doing the everyday work and making themselves vulnerable to the virus in order for the economy to continue, and now classified as essential workers and thanked for their labor when in fact it is part of their own survival. And clearly, I think if there isn't a better time to really think about how the way that these structural challenges that have always been upon us continue to be accentuated in this period. And so I think Christopher's point about what can international law do to attend to this issue is an apt one. It's really a starting place for us. So thanks for getting us started with that conversation. I'm eager to hear what my colleagues have to say, especially Christopher, in light of his tweet.
I can pick up where from something Kamari mentioned about finding the bodies of children murdered in residential schools. Obviously, Canada is in a process of mourning about this, but one thing, this is also happening in the United States, although with less press around it. And one thing I want to maybe highlight is the concept of white surprise. No Indigenous person is surprised that these bodies are there. They knew that their loved ones were missing, and that no one did anything about it. And to have a bunch of well-meaning white people all over social media expressing their outrage and surprise at moments like this can actually be another harm to those who have been trying to tell these stories for a really long time. This is something that's been happening here where I live in what settlers call Pennsylvania, but what the Lenni Lenape people, who are the traditional owners of the land, call Lenape-Hawking. We also have a residential school where a number of remains were recently dug up and returned to some of the Indigenous groups whose loved ones went missing. So that's, a way in which structural injustice might insist itself into our lives by showing who has the luxury of not knowing things. Also, one thing I might mention as a white woman living in the United States, that I just got over having cancer a year ago, but what that means is that I've had 3 shots of Pfizer and didn't have any trouble getting my hands on that. Whereas others might live in neighborhoods that aren't well served, or are being discouraged from seeking out the types of resources that would get them the shot for no money at all. There are all kinds of inequalities that on paper might not even look like they're inequalities, because you could say, hey, the shot's being made available free to anyone who wants it. But it's more complicated in terms of stories of public health, who's going to seek it out, who can have the time off of work or the bus fare to get to the place that isn't close to where they live in order to get it. So those are some of the things that I think matter about the current moment in structural injustice.
So I feel like I should say something about my tweet now, which turns out to be the most sort of successful bit of scholarship I've managed to cobble together over the years. So I mean, the tweet was in a moment of frustration, I guess, but also illumination at how we have these two things. And I won't read the whole tweet, but the gist of the tweet was that this moment of global racialized persecution and death, both direct and systemic, international law doesn't have the legal framework, the economic incentive, or the symbolic vocabulary to do anything about it. And this is international justice. And this is international justice was kind of drawing on something that Du Bois wrote during World War II, when people were rushing to defend Europe. And he said, this is Europe. This is the face of Europe laid bare. And in many senses, I think the pandemic and the absence of any meaningful international legal response to the racialized violence that is every day, but it has come to the surface in the recent times, is international law. This is how international justice works. So I kind of wanted to profit from that moment of, as you say, white surprise, to say, actually, this is what scholars have been pointing out for a very long time. There's nothing new that's happening here. It just seems to be laid bare in a unique way. And I think what's interesting, what I've tried to do with the work of Kumari and others along the way is to try to point out both how there is this complete absence of anything meaningful concerning justice when it comes to slavery, imperialism, colonialism, but also that these moments are not moments of sort of aberrant impunity, that these moments are moments of reconfiguration of the structures that perpetuate injustice. So there's a relationship between these high moments of justice for the West and injustice for the rest, and the kind of racialized structure that they lay in place and reinvigorate. And so I'm really interested in thinking through how we might tie together the intuitions of international criminal law as having this justice deficit when it comes to particular types of crimes. To paraphrase or to Charles Mills, when white people say justice, they mean just us, right? And international law says justice, they mean just a particular section of the world. But to think about how that relates to the more everyday, the more quotidian forms of racial capitalism and the structure that are put in place in those moments. And here I'm thinking of Kumari's work on kind of the spectacularization of certain figures in international criminal law at the expense of paying attention to the structures, the political economic structures that underlie the conflict. And I think there's something resonant about that, the kind of spectacularization of certain moments of racialized violence, certain moments of racism, the way Toni Morrison said, racism is always a distraction. That kind of focus on that one moment in some ways might allow us, if we think hard enough, to link that back to the everyday structural violence, but might also drive us away from that particular analytic. Unless we draw on the resources of people who have been saying for a long time, there is a relationship between, for example, the reconfiguration of Nuremberg and the reinvention of the international economic and political order. So I welcome the opportunity to think through those things. And I think this moment has both the potential to outrun us if we spectacularize and don't pay attention to what's going on, but also the way that some allies perhaps have suddenly cottoned on to the everyday violence of international order might be a way for us to then backtrace how this is not a new story, that there's always been. And Siba Gropri makes the wonderful point that the end of 8th of May, I think the end of World War II, the moment of the end of the war was also the massacre at Sétif and the institution of a new international order. So these moments tend to collide, both the justice of the West and the reconfiguration or rearticulation of racial capitalism have this intimacy that I think this moment allows us perhaps to tease out if we allow ourselves to pay attention to it and pay attention to the people who have been saying this for a long time.
Yeah, that's really helpful and generative. I think both comments from Christopher and Jill, and it makes me think of Jill's earlier point about not knowing and white surprise. I think that's a great entree into what many scholars today are thinking about in relation to the violence of not knowing. That we actually take seriously the kind of work that goes into not knowing, turning a blind eye, not reckoning with privilege as it points us, as it looks straight in the face at us. What is the work, what's the labor that goes into those ellipses and forms of exclusions? And I think it's generative to escalate the kind of these politics of ignorance and not knowing to a level of violence, a kind of violence of refusal, but of the other sort, not of the revolutionary sort, but of the refusal to see and the labor that goes into that refusal to see. It's historic, but it's contemporary. And so I've found, I think it's quite useful to begin the story with that inversion.
Jill, I'm wondering, did you want to pick back up on that or respond?
Sure. I am in complete agreement. There's a refusal to see, and I think it's a way, in a way, linked to some work I've already done in ethical loneliness, which is about situations that are designed for hearings, such as trials and truth commissions, where what people say doesn't actually get heard well. So someone might test, for instance, in a legal trial, the facts of the case matter, but the facts of the case narrowly construed according to the law may not correspond to what the people most harmed by the situation need to say or have heard. In other situations, someone's training might stop them from being able to hear what someone's story is. If you're trained to only look for the facts of the case or the symptoms for a diagnosis, you might not hear some of the other things going on, or your own desire to shield yourself from harm, not wanting to actually understand what someone else's trauma is, so therefore refusing it on some level subconsciously. All of these are ways in which we might refuse to see or hear. Some of them we might do willfully, and others not even notice that we're doing it. And again, sometimes this has to do with privilege, the privilege of not having to fully understand. But sometimes someone who might really actually be working, might be their life's work to try to make a difference, might still be failing to hear because of all kinds of structural and affective forces that work on us on a daily basis.
Thank you very much. And picking up on what both Kumari and Jill were saying about privilege, I wonder if we could return, Christopher, to what you were saying before about the justice deficit and try to think through this concept a bit more together, because I think it raises questions. Jill, you were just talking about at the individual level of perhaps someone not being on the receiving end of justice because there was an inadequate institutional response or hearing of them. But then also we can think about it, or when Christopher, you first raised it, I was thinking in terms of where institutions turn their attention to what kinds of issues are they directed, where, and the individualization of culpability that many of you have worked on in your research. So I'm wondering if you could say a bit more about that and then see if others have things to add.
Yeah, thanks, Sarah. So, I mean, there's an important sort of bridge between the two, right? So Charles Mills, when he writes the racial contract and sort of scaffolds out what he means when he says, when white people say justice, they mean justice. So essential to that is what he calls an epistemology of ignorance, a particular way that people who are racialized as white and are signatories or beneficiaries of white supremacy get the world wrong. And they get the world wrong because they cannot see the forms of privilege. And that's essential to maintaining the racial contract. And I think thinking through that is important in terms of both how we as international lawyers conceptualize discussions about race. So a shout out to Robbie Shilliam, who's an international relations scholar, has written a piece on race and the racial agenda, racialism and the race agenda, where he points out that the conversations in the IR, and I think this is true for international law, about race are framed from the perspective of the master, from the perspective of the individual races, and not from the structures or from the perspective of those that are victims of that. And I think that's an important way to think through, as I say, not just how we tell these stories, but who we tell them with. What kind of archives do we draw on to tell these stories? Because this, as I say, Charles Mills again makes the same point. A lot of the things that count for revolutionary or inspired ideas is just sort of mainstay Black oppositional thought that people don't pay attention to. So I think there's something in not just thinking through sort of patterns of ignorance and structure of ignorance, but also where we get our knowledge from as a particular way of thinking through that. And then also to pull back to the first question. So Jemima Pierre makes the point about part of the reason we can't see the link of race or the everyday life of racial capitalism is because we have this distinction between thinking about colonialism and thinking about slavery. And she says that's an epistemic blindness that is trained, that we trained, I think this is definitely true of international lawyers, we trained to have a fairly good account of imperialism and not so much a good account of slavery. And I think that the same might be true of critical race theory. So critical race theory has a good account of slavery, but less of an account of imperialism. And James Gatty's written recently about how we think about those literatures together. So I guess to think through what makes us unable to see something called international justice, or what makes us, I think, perpetuate this just us, a particular vision, a limited sort of deracinated vision of justice, is part our knowledge practices, part our archive, and part how we put those things together. And I think international criminal law is particularly bad at trying to understand history when it isn't a particular form of history. So I guess justice, I think, has to start with both the historicizing of our own field, to think about how is it that we didn't prosecute slavery, colonialism, apartheid, but also what is it about our resources and our archive that mean that we can't see these things that seem so very obvious to everyone who isn't trained in those particular blindnesses and those structures of knowledge as well.
Yeah, I think that's a really good point. And I think I can say something about the problem of what counts as an archive, just from one of the cases that I'm really interested in. This is a Canadian case, but it could, in a different world, be an international law case because it's between Canada and an Indigenous nation. The fact that it's a Canadian case is part of the problem when it comes to how settler colonialism adjudicates the problem of having stolen land, basically. But a case called Delgamuukw v. British Columbia is really about whether testimony by Indigenous elders using oral history can be construed as valid evidence. And so part of the question is oral history an archive? Can it count as a way of giving law? I think the obvious answers to both of those questions is yes. And I think anyone who spent even a little bit of time looking at what the purpose of that type of story and testimony is would come to that conclusion. But legal training and probably a kind of imperialism makes it really difficult for a Canadian constitutional lawyer to hear those things and find in it anything resembling law. And that is also what you call an epistemic blindness and also racism.
I'm wondering, just to both of these sets of points, what kinds of practices can we as scholars, as teachers, can students be engaging in to try to undo those blind spots, to try to undo those embedded ways of framing things? And this is open to any of you who have a particular response.
Yeah, I guess I'll come in here and by saying that, of course, we encourage our students to think critically about their world, to pose the type of questions that need to be posed. But in doing that, one of the challenges that we face is that we're already embedded in particular frameworks. I mean, in the case of legality, you know, one of the core questions is who is responsible, who committed the crime, is there mens rea, what about actus reus, is, you know, how do we think about culpability? And in many ways, many of us are also teaching our students to ask different questions, that the questions around which legality determines culpability aren't always the right questions for us in thinking critically about our social condition. And so that's one place to start, to think about the embeddedness of the structures of legal thinking and how we move outside of those structures and ask different types of questions. The other point that really is encouraging, and I think it's really a wonderful example of counter legality, and it is the kind of counter trials that we see underway and that we have seen historically, where, you know, sometimes in the form of plays, sometimes in the form of physical trials where, you know, around land, around democracy, around settler colonialism. There are many, many, many examples around the world in which there are these counter trials where sort of people's courts, where people are posing different questions and defying the confines of legality, and instead framing the questions using different points of departure. And I think that they're wonderful places to start. And they're also, you know, some of these counter trials are published, they're available for engagement. We can use them in our teaching, even as we read legal cases. You know, we read Nuremberg trials, we read a whole range of trials from the International Court. We might, in our teaching, use excerpts from some of the what's seen as canonical trials and read them against other trials. And so I think that's one of the places to go as we think about critically engaged international law. How do we teach it? How do we think it differently? And what does it take to do that? What are the knowledge bases that we can draw on in order to tell a different story about how we make sense of injustice?
Thank you very much for that, Kumari. And I think what you've sketched out here is something that all of you are deeply invested in your work, which is looking at the confines of legality, as you called it. And I'm thinking, Jill, about your work in particular and how you've argued for a different way of understanding what constitutes testimony. So in a sense, what this is asking is, how can we undo the colonial structures that exist, particularly in settler colonial legal contexts, and think about what voices are excluded and what kinds of ways of undoing those frameworks might we be invested in thinking about more. So I'm wondering if I could invite you to speak more about your work in this light, or anything that you'd like to follow on from Kumari's remarks.
Sure. I'll start by mentioning that I agree with Kumari that all the different materials in the classroom can make a huge difference. I recently used some of the poetry of Billy Ray Belcourt, who is a Cree poet from Canada, when I was trying to get my ethics students to understand the depth of what is wrong with settler colonial attitudes towards Indigenous resurgence. And I was a little bit worried about teaching poetry in an ethics class, but it actually made them understand it at a level that the legal cases and the, the kind of social science articles did not. So I think there's a way in which the brain can be made to hear things differently when you approach a problem from many different angles. I've also recently been experimenting with seeing what happens when you look at a set of legal cases using a frame that isn't traditionally legal. So the book that I'm writing that you mentioned at the beginning, called Temporal Privilege, is about what happens when you look at a few different legal cases that have been difficult and try to find in them a story about time rather than a story about law. When you do that, you ask different questions and certain things become more easy to see. So for instance, in the Delgamuukw case that I mentioned earlier, Canada tells a story about the history of its existence and claims jurisdiction based on settler colonialism's expansion. The Kitsan and Wet'suwet'en peoples tell a story where Canada is a blip on the radar of their existence. And the stories that they tell aren't necessarily only linear temporalities, but are oral histories that use past events to think about present events, and in ways that might even modify what the past is, such that a lawyer hearing this in court thinks, oh, well, that means that they don't actually know what the past is, because how could it be unstable? I mean, any historian will tell you that the past could be unstable. But so I do think that there's ways in which we can take what we know about law, subject it to an interruption. And when you hear a question that seems like it can't possibly be a legal question, or you hear an assertion of law that seems like it can't possibly offer you a way of determining jurisdiction or making a judgment, maybe stopping to think, am I the problem rather than this other thing? Is it my frame rather than that one that needs to be readjusted? None of us are ever going to be perfect at breaking out of our frames and our training, but giving ourselves a moment of pause before becoming certain that the training gives you the right answer strikes me as a meaningful thing for a lot of us to do.
Thank you so much. And building on that, it seems like there's at least two orders on which we're discussing this. One is, how do we try to disrupt the framing of the legal institutions and what they take as given? And then also, how do we try to provoke legal forms with their particular doctrinal and other modes of thinking through turning to different modes of expression? And you used the example of poetry in your own pedagogy. And I wanted to turn to Christopher now and ask him to say a little bit more about the project of literature and international law at the edge and the use of literature that you've made in some of your own research.
Yeah, thanks. I mean, I guess this began in a sense of trying to seek out an alternative archive of international thought. So if you were looking to find voices that weren't within the classical international legal and more general Western canon, where would you find these? And I found in a number of ways, certainly in my research, that novels are sometimes the first and the best place to look in a number of ways. So for example, a couple of years ago, we had a sudden recognition that the Mau Mau were subject to various horrific crimes, and there was a whole someone won a history prize for uncovering that for Western historians, and there was a case in London about it. If you read any novel by Ngugi wa Thiong'o, you get a very clear historical account of precisely the types of injustices that happened in Kenya and any other post-colonial state for that matter. So there's a documentary, I think, in some senses, what really happened is better expressed often in novels for people that are excluded from or don't frankly care to be international lawyers, which I think is a wonderful choice to make. So I think just as a documentary archive, there's a value to that. I also think there's a value to the way that novels can sometimes inscribe, to use Toni Morrison, inscribe what's on the international mind. So to inscribe what's really going on. So a very, very useful novel for me has been Du Bois's The Dark Princess, which for me is the most compelling account of white supremacy as a global world-making structure, more so than even to this day. And I think in many ways, again, to punt Charles Mills, much of the work that Charles Mills does about the racial contract and racial justice is anticipated by Du Bois's ability through the novel to show the various different political, moral, social, and epistemological articulations of global white supremacy. So sometimes novels can reach and inscribe things that don't seem to be able to be legible in text. And also just as then imagining a world otherwise, right? So critical fabulations, a way of trying to hold the world up in a certain light to show precisely how it's structured, not just to think of a different world outside the confines of particular epistemic universes or disciplines, but also to push against the limits of those disciplines in the same way that Hartman has suggested we can use critical fabulation to show the limits of the archive. I think using novels to show the limits of what's thinkable about international justice, what type of things can we not conceive of within a particular discipline or frame, whether it be international or international relations, novels can sometimes hold us to that, hold the light to these things that we take to be truths and show them to be constructions. And I found certainly science fiction and the work of Octavia Butler has been very helpful for thinking through what a different world might look like outside of sort of the rigid legal world created by international lawyers.
Thank you.
Yeah, I wouldn't mind coming in here on this point. Christopher and Jill, I really love the direction of this conversation, and Christopher's point, citing Saidiya Hartman, I think is really wonderful. And I wanted to tease out a couple of points in relation to that, because I think at the heart of, so Saidiya's concept of critical fabulation is about a recognition that, for one, this idea of truth and what we see as truth or evidence in the context of law is far more complicated, and that part of what we need to do is to recognize that fabulation, that we need to piece together that all histories and stories of the past and people's reflections of the present are really a cobbling together of a range of things, including the frameworks through which they decipher what truth is and what knowledge is. And that idea of critical fabulation, of course, is important for those of us whose historical trajectory emerges from the figure of the slave ship, in which lineage and knowing and the past is either about being captive and being a number on a ship's manifest, or we sort of make up the story of our past, when we try to go beyond 2, 3, 4, 5 generations. And this idea of critical fabulation then is a way of arresting the notion that there is one truth, and that history, big H, means something, and it destabilizes it. And I think it's a wonderful way of bringing to law and thinking about lawmaking and the teaching of law through the question about how we know, what is evidence, what is the basis upon which we know. And some of that work involves putting to rest the idea of the liberal all-knowing subject, and the subject with a past that is knowable, that is discoverable. And of course, in so much of her work, it is about the Black Atlantic and the figure of the slave ship and the complexities of knowing, but it's also about the human condition. It's about what we know, the challenges around knowledge. And so I just, to end that thought, I think it's worth, when we think about critical international law and questions of legality, there are a number of arenas that we need to interrogate. One of them has to do with the problem of method, including legal method. What are the methodologies that we teach? How do we write legal? How do we teach legal writing? There are problems around, and I think Jill clarified this point very nicely, around what constitutes legitimate evidence and knowledge forms, and what doesn't, and what are the legal questions that courts are struggling with in thinking what kinds of testimonies and renditions of knowledge can be admitted before the court. But then there's also the problem of representation. And we see a significant amount of that in international law, and we maybe could talk about that a bit later. But the last two that I think are part of this challenge around fragments and knowledge have to do with the problem of scientific legality, as well as the problem of evidence. And so in many ways, I think some of what I hear us saying has to do with reformulations of that knowledge production, and what it would take to open wide, the doors of different critical inquiry. What would it look like? What do we take as legitimate forms of evidence that then become the basis for knowledge formulations, and that we can sit with, not through the prism of truth, but through another configuration of what that knowledge is and what it means. And it's not truth or untruth. Clearly, that's not what Jill is saying, but that there are different ways of telling the story of our past and our present, and of our aspirations for the future, that take a different form, that could take different forms. And it means that we have to be able to see those forms as legitimate forms through which people tell the story of their life and of their past.
Yeah, I think those are really important points to keep in mind. I think, picking up on your point on Kamari's point about knowledge production, I think one thing that a certain kind of liberalism has burdened us with is this idea that only institutions of justice can do justice, that we as individuals or groups of people working together don't have the power to rethink or grant or dwell alongside people in justice. And so whenever something goes wrong, what that is, we think, well, there ought to be a law, or we turn to an institution to do something about it, or we say we need to create a new institution to do something about it, or we say we need to fix an institution that isn't doing well enough. And I'm not saying that those things aren't things we should be doing, but sometimes it seems to be done in such a way that we forget to also build in ourselves and those around us capacities to respond to harm, help each other, live in such a way that we make the world around us better for other people simply by how we dwell in it. Sometimes when my students are full of despair, and since I teach ethics and justice related things in the contemporary world, they often are, I will remind them that some of them are going to go on and do huge, great things that will get noticed, and others of them are going to live lives where they make a difference in the people around them by how they talk and act with regard to other people. You can make a negative difference, you can make a positive difference. And the way it feels to live in the world is radically impacted by how other people look at you. And how people embody their response to you. All of us can remember that as we're walking through the world, and be the type of people who make the world livable for others. And you can say that in a small way, like I can be nice to someone, but also if you think about if you live in a community that has a history of deep injustice, and probably all of us do, it's going to feel different for some people to live there than it is for others, even when they're neighbors. So if we pay attention to the way in which, if somebody is a descendant of a history of injustice or is recovering from a recent harm, it matters that their neighbors or the people surrounding them know that what happened shouldn't have happened, and are dedicated to making sure it can't happen again. Or if they live near people who think oh, it doesn't, why are you still mad? Why did, or they deny that it ever happened in the first place. Those are two really different places to live. And it's caused not by institutions, but by the way people dwell alongside each other. Institutions can sometimes have an impact on that, but there's a lot of things that institutions cannot get done on their own. And so we need to also have the training not to rely on only that.
Yeah, in terms of thinking through these alternative institutions or spaces of justice or conceptions of justice, and relating it to sort of alternative archives or imaginaries of what the future might be and what the past might have been, I think there's a question of also responsibility for what we do with these fragments that we tease out. Right? So as I say this as a white scholar and a settler at that, in a neo-colonial state, that there's a sense that when we discover these things, do we want to hand these imaginaries, these alternative conceptions of justice over to law and over to the assemblage of international criminal law, because that comes at a cost. Right? There's a sense in which, and I've seen this, someone who I spent a long time thinking about is Du Bois, and the way that Du Bois's work has been cut and dissected and stuck into histories of slavery or histories of internationalism or histories of human rights. And what's left behind is the tradition that he comes with, but also the imaginaries that made those fragments meaningful. So I guess it's a question of both sort of epistemic responsibility as scholars. What do we do with these things that we find? Do we leave them in the archive for people who are better placed to do things with these imaginaries? And then I guess as a tactical question, how some of these things do not translate. Right? So law seems to be an all-powerful sovereign that can turn any radical project into a reformist agenda. And so I have this deep sense that sort of a wanting to hold on to these things as something that waits for another time or a better time, and I guess on time and temporality, thinking about whether these are untimely for that very reason, that there's never a right time to prosecute apartheid, or there's never a right time for these types of imaginaries, at least not in the way that we configure temporality.
Thank you, all three of you, so much for these different connected thoughts. And we've seen how some of the really important themes that are emerging out of this have to do with the production of authority, alongside that, the production of knowledge, faith in institutions, sometimes blind faith in institutions, how certain disciplines, in a sense, reinscribe that faith. And international law is certainly one where its role in reproducing structures of colonialism has been interrogated by various scholars, particularly in the area of third world approaches to international law. And I'm wondering if you have some thoughts around what kind of critical reserves we might be able to draw upon to prevent this kind of reactionary, as you were describing it, Christopher, kind of reactionary reinscription of these forms and areas of knowledge.
Sorry, so was that directed at me?
Oh, no, I'm sorry. That was directed at all three of you, but I see Kamari was coming in.
Go ahead, Kamari.
I was coming in to call on Christopher. I thought that Christopher could very nicely deal with this question.
So please continue.
I guess part of this, I is sort of to draw on Siva Grogbu's work on thinking through, I guess, beyond Eurocentrism, what would another archive look like? How you would have to not just reimagine the spaces, but the very imaginaries of the discipline, so the comforting myths or the myths of origin. And even then, I have my doubts. I mean, to my mind, a lot of what comes out as being critical kind of third world internationalism from historians and international lawyers is just taking black and brown figures and putting them in a story, in a white story, right? To repurpose or to rejig the 12 story that says, and there's very good examples of this in recent history of imperialism, when 12 scholars have said, international was formed in the colonies. And so historians go out and find as many white people as they can find in the colonies and tell a new story about international law, right? That the stories of Haiti or enslavement or the various other non-white actors are somehow in the frame, but always slip out of it at a particular time. And I think in some senses, even contemporary discussions of slavery, the metaphorization of slavery and what that means to make it into a metaphor as opposed to a specific historical occurrence is part of that. So it's my personal way to do this is to try and learn everything I've ever learned and try and sort of enmesh myself in an archive that's completely different, and pay very close attention to the things that you read and the people that you read with and cite. The story I always tell my students is I had written a couple of things in international criminal law. I was 10 years ago, and I just went through my footnotes and I realized that I didn't have cited white men. The whole thing was white men or a court. And then I had to sit back and think, well, there's certainly an account of the things I'm doing that doesn't involve only white men speaking. So what type of archive or what type of people, and wonderfully I stumbled upon Kamari's work and the work of people like Siba and Michelle Trulio, and then went back into the histories of Black internationalism to try to find a set of scholars to think this with. But I think it takes a commitment and in some senses, always being attentive to the epistemic blindness of whiteness, right? To know that there are some things that, as Charles Moore said, that I will always just get wrong. So to put yourself in good company would be one way to do it. And hopefully to be ready to be wrong about these things as well.
Yeah, and I wouldn't mind coming in here because Christopher's comment makes me think of, or reminds me of, Chimanda's statement, or at least I think it was her TED lecture called "The Problem with the Single Story," and in that, in her work, there's this wonderful imagery of her as a young girl in Nigeria growing up, and she reflects on her characters. She wanted to be a writer, and she reflected on her characters, and the characters she wrote into her little books at the time were characters that were shaped by much of the reading that she had done as a student of literature. And she invokes discussions about the weather and about apples and about things that were so foreign to her everyday life, but they were part of a formulation and conversation pieces and obsessions in Europe and in North America that actually was alien to her own experience, yet it was part of the structure of engagement that she came to know through the novel. And she, in reclaiming her voice and resituating her work where she is, the basis on which people, the characters engaged with each other involved rethinking, undoing the very concepts, the knowledge base, the forms of representation that she had been taught to know. And we also see that with, Michelle Cliff's reclaiming the name that I was taught to despise, or reclaiming the tropes that were, as a child, tropes that were negative tropes. What does it take to flip the script, to produce a different trajectory? And I start with that because Christopher's provocation led me to those couple of thoughts, but I think they are in the radical humanism initiative that I'm involved in. One of the things that we're trying to do around these reactionary reinscriptions is to imagine different archives, as Chris and Christopher and Jill have outlined, but also to think of the whole range of spaces that we need to do differently, that we need to think of how we meet, the conference form. One of my colleagues has really influenced my thinking on that point, that we not go to the typical hotel and sit down around the room, around the table, and engage in knowledge production, that's not the only way to engage, and other spaces produce other creative ways of thinking about ourselves in the world. So yes, the archives, yes, the way that we engage with space and what is around us, but also for those of us who are educators, it's the way that we evaluate. Maybe we have our students also engage in evaluating their own work. And we put in place the criteria through which they consider it, or we co-construct the measures that are used for evaluation. It's not just the authorial professor who assigns a grade. There are a whole set of ways, and I think one of the most persuasive is the archive itself. And this is something that Christopher has started us off with, and I'm so convinced by it. And I think one of the challenges, though, with the archive, with the syllabus as a domain for knowledge production, is that it forces us, those of us who claim the place of expert, to sometimes be the learners, right? That, you know, we approach knowledge production from a place of subordinate, you know, that we assume a different posture to knowledge, that we are not the authorial spouting out the professorial knowledge about a thing, but that we are co-learning with our students. And especially in contexts that we're not as familiar with, but we're willing to entertain the novel or the poem. And this is something that Jill had also said, and I really loved what she said about the poem, and that, you know, that we may feel insecure if, you know, those of us trained in the social sciences or philosophy or law might feel insecure about teaching a poem in a class that is a class about jurisdiction. You know, how do we train ourselves to think differently? How do we train ourselves to read text differently that were not part of our training? So these are just some things I think that are worth foregrounding as we consider the problem, what we need to do to prevent this reactionary reinscription that Sarah has helped to provoke in our discussion.
To be fair, I think I was actually building on something that Christopher said there. And what I'm really seeing emerging from out of this conversation is a kind of attempt to focus on how do we unlearn various practices. So Christopher, for example, you were talking about looking back at previous work and noting citationality that tended to foreground the work of, say, white male scholars. And how can we adopt these kinds of reflexive practices in our own teaching and research, and making ourselves, in that sense, perpetually students of unlearning things. And so I see that really emerging as a theme. And Kumari, you had talked about what would it take to flip the script. So just to bring it back to international law and legal forms, I'm thinking for all of you in your work, one thing that's been a regular theme is some of the problems with international legal forms in telling a singular narrative. So coming back to one of the things Jill had said earlier, what about a plurality of narratives, and not only the narratives themselves and strands of narration, but also sources of what is considered to be an authoritative part of the narration. And so if we can think maybe a little bit about perhaps past work you've done, critical work on these institutions, and how might we imagine other possibilities. Jill, I had been asking you a little bit earlier on about the recognition of alternative forms of evidence in these fora, where there's always the potential risk that it just, to some extent, recolonizes or captures those other forms, because as we know, Western law does seem to be somewhat inherently imperial. And quite literally, I'm thinking about, Christopher, you being in the South African context, where in many cases it's about undoing legal codes that were inherited from colonial powers and trying to reconstitute them. So somehow this work of reconstituting the archive, whether it's about whose work is in it that's considered authoritative, reconstituting the archive of law, what it prevents us and allows us to see. And I'm wondering if these what I'm trying to pull together here provokes any responses from you in terms of concrete examples related to institutions or other things you've come across in your own work and thinking. So if anyone would like to come in, I welcome you to respond.
I could say something short and maybe just a little bit to the side, but I recently had the experience. I teach a class called Forgiveness, Mourning, and Mercy in Law and Politics. And I hadn't had the opportunity to teach it in 8 years due to pressures on me to make sure that my program got its core courses taught. But I recently was able to teach it for the first time in 8 years. And so I revised the syllabus, because obviously things change when you're talking about contemporary things. And I learned It wasn't all white people, but it was too many. And also, I was assigning so much reading. Like, it was way too much. Do I want them to read well, or do I want them to like be overwhelmed, you know? And so it made me, and then I also started to think about, well, what do I want their experience to be? What do I want them to take away? And I think this matters also in terms of the type of work that we all do. I started to think not only about what are the different identities of the authors, but also what are the different forms of writing. And because I want the students to be able to think about how different forms make different types of meaning possible. So poetry, your typical academic writing, kind of hard jargony academic writing versus the type where someone has clearly worked to make it accessible, novels, testimony from people, all kinds of different things that actually allow students to see that each form assumes a world and a meaning and sometimes a kind of training, and therefore excludes some ways of thinking about things while drawing others in. And what can we do to make those things speak to each other? I think giving ourselves all the practice of that is one way to kind of open up our thinking about legal forms. And when it comes to an institution like the ICC, I think on paper, what they're trying to do is be responsive in a broad justice-based type of a way to defendants, victims, and larger communities. When you start to look more closely at what they're doing, it doesn't seem as if they're being all very successful at the broader thing, but at least you can say that they're trying. And part of it seems like it's because of the rules of the game require that they cannot think outside the box.
So I suppose to come back.
Go ahead. I'm saying in the middle of a big storm behind me, so I'm gonna be brief. So thinking through examples of this, I think, so to contradict myself. So the one is to think through, on one level, this is not hard to do if you just sort of read closely enough. So to say that every time I look for an account of international criminal law that centers white supremacy, it's really just beneath the surface. I mean, sometimes it's so obviously just beneath the surface that it seems like and it has, I'm sure, been deliberately overlooked. So there's a sense that our discussions about justice, and I think Charles Mills has done a good job of doing this, is so deeply idealized and often unhistorical that it doesn't take a lot to try to show precisely how, and Mari's done this as well very well in her work, precisely how, if you look close enough, you can see these things unfold in historical time. But the problem is also there's a sort of risk of reifying the archive, that if we just get a better set of histories or a more precise historical account, what we'll get is a more just product. And I think that overlooks both how these histories don't work through necessarily the archives they proclaim, right? So that in actual fact, we might marginalize ourselves by saying, well, we do things that are not legal and we use poems and novels, but you guys work with archives. Well, a lot of the stuff about international criminal law is just white fantasy. It's not deeply historical, it's not archival, it's just fantasies of white supremacy. And it's a long story of white saviorhood. So a lot of it is not at all being driven by the archive that it pretends to connect to. And it's not being received by that archive. That's not how history works. The history is being received by particular audiences who matter and construct the history in those moments. So there's both a temptation to say we can, and I think I've done this in more sort of work a couple of years ago, to say I get the history of international law in Africa right by showing all these interesting ironies and parallels and untold historical stories. This will show them, but people are not reading that because they don't want that story. That's not how they're getting their history. They're getting their history through a particular understanding of the world and a certain idea of the West that makes them blind to any amount of archival sort of rehistoricization. So it's both a kind of, I guess, to contradict myself, a plea to doing the history, but also recognizing how history actually works, to paraphrase Trulio's work, that the way this history is received is not changed by 1,000 more stories of slavery or 1,000 more stories of international criminal law. If the way the audience is receiving it is not amenable to hearing those stories. And I think that's kind of where the two projects might meet.
Thank you so much, Christopher. As you were talking, I was thinking about one thing that's coming out is the question of audience. Who's the audience of these various institutional performances, and how are they being received? And in Frederick McGray's work, he's basically argued that the constituency of the ICC in many instances seems to be the court itself. And I saw something recently that reminded me of this, which was the opening of the new ICC premises. And if you scroll to the end of that video, there's this performance, literally, of Michael Jackson's Heal the World within the well of the courtroom, with different people singing. And there's really this sense that this is actually a performance directed toward the personnel involved in the production of justice this year. So I'm wondering if maybe we could turn to Kumari now and ask a bit about you. I know you've been thinking about the work of Sarah Ahmed recently on non-performatives, and just thinking about the kind of spectacles of justice that you've talked about in your previous work. And I'm wondering if you could perhaps say a bit more about this, the ICC in a kind of spectacular dimension. It doesn't necessarily have to be limited to the ICC. Perhaps you'd rather speak about the affective dimensions of the production of international justice.
Yeah, that's a big one. How much time do we have? I think maybe I'll just say a few things to open the conversation around this, and let Jill and Christopher also come in on thinking about these forms of spectacularization. Yeah, I find Sarah Ahmed's work generative in so many ways, and her, the politics of the apology, the politics of non-performatives, I think is terrific. And in part, for those of you who might not have read the conceptualization, because in fact I build on it to talk about legal non-performatives, but non-performatives for Ahmed are ways of engaging in certain forms of speech that do nothing but engage in those forms of speech, that they're not transformative, they don't do anything, and their failure is part of their work. So when an institutional president at a university stands up and says, we believe in diversity, equity, we are against inequality, and that speech act itself is a statement about the posture of the university, yet inequity and the lack of diversity continues to persist to enable that institution to remain number one in its evaluation scores. In part, the Speech Act it does something, right? It asserts its place in the membership of contemporary liberal universities, but at the same time, it does nothing to uncover and disrupt the forms of structural inequality that are about so many other things, that are about the books that we read, they're about the formulas that we use, they're not just about who we hire and who sits around the table, they're about what we value, the kind of knowledge forms that are important. They're about so many other things that need to be toppled and rethought if we're actually going to address the forms of inequality that exist. And so, in building on that conception to talk about why things don't change in these international justice circuits, I think about legal non-performatives and the kind of articulations where the Office of the Prosecutor at the ICC might say, this is not about politics, this is about a law. It's about the law. The law is my Bible. This is Fatou Bensouda's line. And in saying that, then that may be followed with a statement about victims, those victimized by violence. This is about the victims. We protect the victims. And this is part of the Speech Act. But in fact, we have victims that continue to be victims, people who are constantly being victimized. If we go to Syria, if we go to Palestine, we can move around the world and think about the nature of violence that continues. And the Speech Act itself does nothing but allows the court to adjudicate after people have died or once they've been victimized already. And so I think it's generative to think about non-performatives as their successes in their failure to intervene. And we see this in the legal form, that law is not revolutionary in and of itself, not through the structures of its application, not through the prism of its logic, not through so many things that it doesn't disrupt inequality in and of itself. Yes, there are strategic uses of law, but in and of itself, it just doesn't address the kind of political problems that are at play. And so I think this idea of the legal non-performative is incredibly useful in thinking about how structures of inequality remain and become pervasive, even in the presence of the Speech Act that is meant to suggest otherwise, but that actually is not intended to do so.
As you were speaking, Kumari, I was thinking, okay, what would be the opposite kind of form to something like a legal non-performative? And I was thinking about Jacques Vergès's work on trials of rupture. And so using the institution, in a sense, to tell a story that is more about structural inequalities. So, for example, colonialism, and using the courtroom and the forum that it provides as a way of disrupting these structures. And so it does seem like we can think about what might be the counter to that would be not just this sort of system reinscribing itself in some of the examples that you give with non-performatives, but actual more radical sites. And then we come up against the question of what are some of the limits of legal forms in, once again, constraining and containing and pulling back into what is familiar. And I'm wondering, maybe Jill, if you had any thoughts on this. I know in your work you've been looking at some of the limits of what can be heard in institutional legal contexts.
Sure. I think I'll also mention that Mark Drumble has an article called Victims Who Victimize that does a good job showing how the ICC could have used something like the Ongwen case to rather than turning it into we got the bad guy situation, into a let's use this kind of testimony to learn everything that we can about what made the situation in Uganda one where so many people were offered only bad choices, to get to understand what type of response to that would actually mend the harm done from many different perspectives. And I think that starts to turn us to the way in which law and justice are sometimes aligned with each other and sometimes not. So for me, my thinking of justice, and let's just admit I'm a philosopher, not a lawyer. And so perhaps that gives me some leeway here. But, in order to put right a harm of any kind, really, it could be a simple harm, or it could be a longstanding case of oppression or massive crimes against humanity, you have to do more than punish somebody who happened to be involved in inflicting the harm, right? You also need to think about what the survivors need, what was done to them, and what would start to rebuild a world that was destroyed. And that includes not only survivors, but the community, beneficiaries and bystanders, and what is it that would make that community functional again, and a community where it's less likely that such a thing would be repeated. You may also have to think about perpetrators and what they might need in order to be reintegrated, if, especially in a situation like the Ongwen case, where you're talking about there being hundreds, tens of thousands of child soldiers who might want to have another option for the future. And then on top of all of that, think about how various parts of the community are going to tell stories that conflict with each other. Like, justice has to kind of comprehend all of that and figure out what's the best way to move forward in a world where there's never going to be an ideal answer. Whereas law can do some of that, right? Law can do some of that. It can't do all of that. And so if we get better at asking law to do what it can do, rather than wanting it to do everything, that would free us up to have the different types of training to work at the different aspects of recovery that are needed in those situations. So I'm not somebody who thinks international criminal law doesn't matter. I'm deeply interested in the way that these institutions operate. And it's an interesting historical moment that we're at, where we don't know whether the ICC in the arc of history is going to end up looking like a colonial blip on the radar, a tremendous mistake, or an opportunity that changed the world in a positive way. Like it could end up in a lot of different directions depending on what happens. But I wish that the people that I encountered at the ICC, I wish that I had faith that they were able to think critically about the institution. I don't right now. I think that took us away from the main question, but I'll stop.
This is really helpful, and it also kind of points us to questions about what might alternatives be to a kind of context of accountability that is routed through international criminal law forms. And of course, South Africa has been one state where we've seen forms of what we might call radical experimentation in transitional justice, but we also have seen lots of criticisms of the premises of the Truth and Reconciliation Commission there. That's been a kind of model that has been used elsewhere as well, or at least taken as an inspiration for that. So Christopher, I wonder, as the representative South African in this discussion, if you would have any thoughts on that, on transitional justice in South Africa.
Yeah, so I mean, in some senses, to go back to my tweet, so some of my deep skepticism about the idea of justice comes from Cedric Robinson's account of the TRC. So many of the accounts of the TRC at the time and since have sort of staged this as an account between justice and truth, and that South Africa was an example where we chose truth over justice. And at the time, and very contrary to what people were saying, Cedric Robinson said actually only a lawyer would think justice has any value, that in fact most of us would choose anything over justice. If you think about the justice of slavery or the justice of imperialism, the justice of racialism, or the justice of the greedy, that in actual fact, South Africa in some senses today, and Sepa Ngozi said this recently, that South Africa is a land without justice or truth. You know, we don't really have either. The choice that was made, we didn't have, the truth is crumbling and it was insufficient to begin with, and any promise of justice was both foregone to some extent, but the 350 people that were identified for prosecution haven't been prosecuted in South Africa. There's been no meaningful prosecution for the crime of apartheid in South Africa or elsewhere. And so in some sense, I think apartheid might be a pivot in this sense, and to read sort of Robinson's connection of apartheid back to slavery and forward to the present. So in some senses, the kind of insipid, deracinated and ahistorical justice, liberal justice that comes through the Constitution of South Africa harks back to the justice of Reconstruction, right? So the re-subjectivization post-emancipation through the liberal autonomous subject that sort of reified the white benefactor and said to the formerly enslaved, you are responsible for your freedom in a fundamentally unequal society, such that you would then perform the very thing that you were said to be freed from. So Saadia Hartman's work on this, I think, resonates with kind of what it means to produce justice, a liberal form of justice in a structurally unequal society that's racist in every possible way, in some ways more so than under apartheid. So I think apartheid as an example of how not to do justice in Robinson's term reaches back to that, the reinscription of white supremacy through liberal norms, but also reaches forward. I think in some senses, I tell my students, when you think about apartheid, if you think about apartheid as a heavily lawful project where you had lawful in the sense that it was full of law, there was law prescribing every possible aspect of your life. Well, if you take away those laws and it still maintains itself, which it does, that's not the end of apartheid. It's kind of a form of hyper-apartheid. It's when you cut the strings on Pinocchio and Pinocchio still dances, and it's come to life. And in many senses, the way that apartheid is maintained through formally non-racial and formal legal equality, but through spatialization, through racial capitalism, through white privilege, I think kind of harks forward to the types of justice that we might see in a world that is separated because of COVID and is run through the types of fourth industrial revolution that we keep promising ourselves we're going to learn more about. So in some senses, I think apartheid is both the past and the future as a way to not deal with justice, to create a veneer and to set up a system that really is very successfully reproduced white supremacy in really, really, really sophisticated and sometimes quite blunt ways. I mean, I'm reminded at the beginning of the pandemic when we had discussions about the origins of where it was and bannings about what you can do, where you can move. I mean, apartheid begins with that same thing, right? Apartheid begins in Durban when there's a sanitation scare and people start setting up different movements and saying where you can eat, where you can sleep. So there's a kind of another history to apartheid that begins as a form of epidemic panic. So I think in many senses, apartheid is kind of this microcosm of many histories of white supremacy rolled into one as a very sophisticated technology, but also as perhaps a sort of terrible future for what it means if you do give a form of justice that doesn't have any account for structures, economic structures or historical structures, or the embodiment of white privilege.
Yeah, that reminds me of a story that I wrote a little bit about in Ethical Loneliness, which is, it comes from the aftermath of Antje Krog's Country of My Skull book, which is a moving memoir of her own experience, but also was then criticized for using people's stories in ways they might not have wanted them to be used. And so one of her ways of dealing with that was to look carefully at a story that she had dismissed at the time that it happened, along with most other people, to see, well, what is it about this story that couldn't be heard? And she worked with a couple, it's from a book called There Was This Goat. She basically, there's a woman testifying to the loss of her son, and she keeps saying there was this goat and telling a story that doesn't make sense to anyone, not even really the translator helping her get through it. And everyone treated her like she was irrational and incapable of narrating what was happening in her life. So Antje Krog and a couple of colleagues spent a lot of time talking to the woman, interviewing her, getting to know what the norms of her community were, and came to understand that a goat is always a sign of the care of ancestors and also portends what might happen. And it was actually a deeply, for her, rational way of telling how she knew that something bad might happen, how she knew that she had to do something about getting the remains of her son from where they were, far away from where she lived, to closer to where she lived. And the TRC was set up so that testimony worked in a specific way. It's like, here's what happened, here's how it was a human rights violation, here's what's needed. And because her story couldn't fit into that frame, it couldn't properly be heard. So to a certain extent, the story I tell about it in my book is, A, it is possible to hear stories better than they get heard, but B, the amount of work it took to hear this particular story just shows that it's too much work to hear every story, that it is not possible for institutions to do that good a job at everything. The best we could hope for is that they get better at recognizing what they don't understand, rather than assuming, oh, here's an irrational person who doesn't actually have the capacity to narrate their own life. Oh, I also wanted to add that in my new book, I don't know why this is happening, there's also a very complicated goat story that's going to happen.
Yeah, that's interesting, Jill, the impossibility to hear every story. And in fact, that point, that takeaway leads me to thinking about something that Christopher said earlier, and that I think it's useful to continue along this thread, which is that, we asked the question, what can a prosecution do? Right? What can prosecutions do? So Christopher's example of, the hundreds of people who were never prosecuted really does push us to ask, what do we expect of prosecutions? And this goes back to Mahmoud Mamdani's point that these juridical forms are limited in their possibility to address and arrest structural inequality and the nature of violence in the first place, that there are limits both in its form. You can't hear everyone, not everyone in need of reparative solutions is getting it from a given prosecution, that prosecutions signal norms, they say something, they do the work of expression. We know that and it can be significant, and it can be significant to those who are victimized, but there are limits to the very real issues, I think, that we're discussing today that have to do with structural inequality and justice and the law. One of the things that I think all of us are saying and reflecting on is the extent to which past violence, whether it's colonial embedded violence, whether it's aesthetic violence, what kind of violence it is continuing, it is ongoing. And prosecutions can do very little to, especially in international criminal law, to arrest or invert that process, that there are other things, there are other strategies, there are other ways that we need to start to think about justice using different frames, different formulations. And that's not to say that the expressive role isn't an important role, and there's a place for that. I mean, I keep on saying that, but that we need to be far more creative and far more open to making sense of new ways of envisioning our world, new ways of moving away from the incarceral systems that are with us today, prisons as alternatives to social violence, to the forms of violence that circulate, that we really need to think, desperately need to think creatively about other formulations for dealing with these very real structural inequalities. So yeah, just a point about that. One of the things I wanted to segue, maybe if I can, Sarah, because I did want to say something about the relationship between law and justice and what bothers me in relation to this problematic. And yeah, okay, so let me just say that one of the things that I tried to do in Effective Justice was to demonstrate how in the contemporary period we talk about justice, and there's a presumption that justice is law, that there is a increasing and intensification in that relationship between justice and law. And many people use the critique, we ask for justice, you give us law, as the basis for a critique of law as the solution. And that instead, as we're thinking about justice and its fraught relationship with law, I think increasingly we need to flip that script and continue to look at law and legality within the confines of what is possible at the moment, but to think more deeply about the nature of the political and what it takes to attend to the structures of inequality. And the structures of inequality are not just political and economic, they have to do with white supremacy, they have to do with the very embeddedness of these structures. When we look at the International Criminal Court, all African cases, all cases before the court having to do with African violence and African perpetrators, what does that tell us about the possibility of international criminal law and the inability of the court to pursue, to claim jurisdiction over Syria and pursue, or the Security Council and the inability to act, and some 8+ years and we still see waging violence, or what has happened in Afghanistan. How do we even sleep at night with the realization that it is law and legality that continues to structure the nature of ongoing violence today, that it's not okay. It's far from a comfort place for us. So, I thought it's worth mentioning that this makes me very grumpy, and it is with the popularization of justice language and young people thinking that they're amongst the most radical of this coming generation. There's a lot of work ahead, and it should unsettle us, I think.
So let me try resolve some of Kamari's grumpiness to propose a sort of a hinge or a hook to think through both alternative histories of the international, but also alternative conceptions of justice, which is the Apartheid Convention, right? So the Apartheid Convention is both the product of multiple generations of Black internationalists and Pan-Africanists, and then first generation independence leaders that to try push back against the sort of individualization of accounts of slavery, or the dehistoricization of slavery, or the disconnection of slavery from colonialism and colonialism from apartheid. So there's a trajectory of thinking that ends up with the Apartheid Convention, but also there's a conception of justice in the Apartheid Convention, which is technically part of our canon of international criminal law, which eschews that sort of individualized, depoliticized account of justice, right? Justice in the Apartheid Convention, or injustice, I should say, is the denial of the participation in both the economic and the social and the cultural and the political life of a society. So there's an account of what injustice is that is fed from that archive of resisting attempts to try and exceptionalize colonialism, or to try and place slavery in the past as opposed to its afterlives in the present. So I think as much as I don't want to redeem any of the much of the canon of international criminal law, I think both that understanding of justice in the Apartheid Convention and how it feeds into novels of the time. So for example, Time of the Butcherbird is a good way to think about conceptions of people's justice, right? So both as a sort of a moment in time and a conception of justice, and also as an account of how that justice is invisible to our contemporary disciplinary epistemic community, that the Apartheid Convention is routinely overlooked, even though half the countries in the world have signed up to it. It's always seen as a Soviet conspiracy, which is the most racist way to vilify someone, to say this was produced sort of by these puppeteers. It's the same way the Haitian Revolution was said to be driven by the British or the French or someone else. Always someone else was driving the revolution. So what happens to the Apartheid Convention in international criminal law, its invisibilization, tells us a lot about what the kinds of justice international criminals can and want to see. And what it would take to understand that convention would be a re-envisioning of the entire discipline, which again, it's not hard to do. Bassioni, who wrote the blueprint for the Rome Statute, said it was based on the Apartheid Convention, right? So there's this clear link between the Apartheid Convention and our present, but our inability to see it tells us something about the kind of epistemic blindness of the community of international criminal law. So I think the Apartheid Convention is a way of reinvigorating a broader conception of justice, but also holding to account sort of how that justice becomes silenced on a continuing basis, both through the way we write about it and through how we conceive justice as international justice.
And that also very importantly foregrounds state violence when there's a tendency in the framework of international criminal law to treat individual acts of violence and to, in a sense, spectacularize them or make particular individuals stand in for a much larger structure. And this is a critique that in various ways you all have made in your work. I just wanted to remind the audience that you're very welcome to put questions in the chat, and that will be monitored and we'll be sure to address your questions. And if you like, you can address them to specific panelists or to the panel as a whole. I wanted to return in the meantime to something that Kamari had raised. You had mentioned the work of Mahmoud Mamdani, and I'm thinking about how his work and the work of Robert Meister has done quite a lot to bring the figure of the beneficiary into the frame. So in a sense, what international criminal law does, and we've been focusing on this quite a lot actually in our conversation, but it's quite important, I think, to all of our work, is it focuses on the figure of the perpetrator and the victim, but then completely sidelines the beneficiary, of which in the ways in which you've introduced yourselves in the context of this conversation, we might think that we are all beneficiaries of settler colonial context to some extent. So in a sense, it broadens out responsibility. It shows sometimes tacit and indirect complicity in various forms of injustice. And so I'm wondering if any of you have been interested in the other figures that international criminal law or international law more broadly seems to sideline that you would like to bring back into the frame and into the conversation.
I think it's important that we think about bystanders and beneficiaries, and they don't fit too well in traditional accounts of legal prosecution. But I think Meister's point that a lot of unacknowledged psychic work done by people with privilege who are benefiting from a history of oppression or harm is aimed at converting themselves solely into bystanders who, because they like human rights, know that if they got to go into the past and make a choice, would choose correctly. And that feeling that all that is needed of them is their compassion converts them into people who don't have to feel a current responsibility to change anything. And he wants to bring that to our attention so that we could actually more accurately embrace the ways in which we are, many of us are beneficiaries of a continuing harm, and that we might owe something. Because he's clear that certain types of inheritance from the past are a form of moral luck, and that it's never the case that someone is to blame for luck. And yet sometimes it might be the case that you really ought to do something about certain types of moral luck, especially if they are attached to harms that continue into the present moment, which is the case with settler colonialism and a history of slavery and various other kind of genocidal practices that the human race has undertaken. So it would be, again, I guess, going along with my somewhat anti-institutional vein, it would be interesting if we could build a way for people to consider themselves beneficiaries and know that it's incumbent on them to do something about it. It's not clear what that means. It could mean agreeing to pay more taxes. It could mean collaborating with people in nearby communities to build access to things that are harder to access. There's all kinds of ways it could go, but it basically adds up to a change in attitude as to what you owe to the world. And I think it would do a lot of us really well to consider doing that for ourselves.
Thank you so much, Jill. And I just wanted to welcome some of the audience members who've posed questions. We have a couple now in the chat. First is from Josephine Uineza. Hi, Josephine. One nice thing actually about this format is we're able to speak with people who are quite far away. And at the same time, the question that you pose is a bit about some of the problems related to the pandemic. So the question is, going back to the start of this conversation in relation to COVID-19, what are your thoughts about the manifestation of state power through law? So restrictions during the pandemic and after. And as I read this, it seems directed at the panel or at the group as a whole. So if anyone wants to pick up on this, you're most welcome.
I mean, I'll give it a go if I need to mention a novel. So one way to think about this is when we think about state restrictions is to think that the state or the racial state, right, doesn't stop it in the public sphere. It comes into the private sphere. So the way the racial state upholds the privilege of those who can afford to abstract themselves from society and work on Zoom and live on Zoom and not work in precarious jobs and continue to engage in all the education and employment opportunities, right? So that in some senses, the public sphere is being heavily policed, but the private sphere is being valorized as sort of a safe space, but as one that is deeply racialized, certainly where I come from, in terms of who gets to hide away in their house and order their food from the shop of Amazon and meet on Zoom, right? And who gets to be in precarious jobs that don't allow them to stay out of the so-called state-regulated public space. One way to come at that is a novel that I tend to mention all the time, which is about Kojo Lang, called Major Gentle and the Achimota Wars, and it's written in the 1990s. It's set in 2020, and the sort of premise of the novel is that at some point the West sort of manages to disembody itself from the rest of the world and become completely cyber-based and no longer needs any of the resources, and Africa and the rest of the third world is left to fight over the remaining resources while the West sort of ascends into hyperspace. And in some senses, you can see what happens, certainly in my context, the people that ascend into hyperspace and onto precarious jobs and can work on Zoom and do conferences and see their friends and live in relative safety is overwhelmingly white people, right? And that the people that are bearing the brunt of the so-called public sphere where the regulations are most obvious are the people who are not white. So in some senses, one way to think about the relationship between state regulation and the pandemic is to say that the state is regulating even when we're in our homes. It's keeping us there, keeping us safe, keeping our food there, maintaining the economy that allows us to as white people to avoid the threat of the pandemic and to maintain job security, individual safety. So it's kind of a straightforward CLS move, but to say that it's sort of to collapse the public and the private sphere and say that the state is not only regulating the public sphere, but is upholding the privileges of whiteness that maintain overwhelmingly in the private sphere in the kind of economy that we have, where some people get to be exposed and some people get to be in their homes.
Thank you, Christopher. And the next question also connects up to whiteness and privilege. So not necessarily in the COVID context, but one of the members of the audience has asked, particularly in relation to the tension between law and justice and how law is able to provide justice for some. In the example of apartheid, for those who subscribe to white supremacy, how can this tension be resolved, if at all? So I suppose if we had a bigger conversation with the person who posed this question in the room, I suppose we might have follow-up questions about, is the tension between justice and law, or is the tension about perhaps the colonial nature of some of the legal structures that we're appealing to in their embedded white supremacy that is a product of their history and historical construction? So it seems like a question that raises many other sub-questions for us as a group. And I'm wondering if any of you would like to pick up on this a bit. It also gives us an opportunity to think a bit more about the relationship between law and justice, and then of course that all-important third of structural inequality, which is really something that's central to the conversation as it's unfolded so far.
I've been thinking lately, I mean, in a kind of a small way due to some things that are happening at my own college, about how it is you call upon people who probably do want to do better with regard to their own kind of unacknowledged racism. You know, the way in which if you're raised as privileged in a society that is deeply structurally committed to racism, you will have racism in you, whether you want it or not. And how do you deal with the moments when it can be pointed out to you? And I was getting really upset with some colleagues of mine who weren't interested in cooperating in a non-punitive structure that would allow people to bring to their attention harmful things that might be happening in the classroom. And then someone pointed out to me that adults and people who know that they might be doing something wrong, even if they don't want to, also have to deal with their own vulnerability to how hard it is to be pointed out as doing the wrong thing when you didn't know you were doing it. And so I've been trying to think about what that means in terms of how I might argumentatively or strategically approach a situation where there are always going to be some people who won't change because maybe they just are racist. But there's a lot of people who probably would change if you were able to show them how to conduct themselves differently in an easy way. And that doesn't solve the structural problem, but it begins to open up a possibility for the structural problem to be solved at some point if enough people move beyond wanting to keep the structures that are harmful to everybody. It's not just the people who don't benefit from them that are harmed, but the people who benefit from them and therefore are constantly contributing to reinscribing inequality. They're also harmed. This doesn't really get at the question with the specificity I'd like, but it's kind of something I'm thinking through right now in terms of like, how do you strategize to get through to someone who can be gotten through to in a world where not everybody can?
I'm thinking about intent as you're describing this, and how it seemed like one of the things that made the person hearing this perceive this as harmful to them was that they felt like they were having intent ascribed to them that wasn't there. And so maybe part of that dialogue is about foregrounding how we're so primed to think about intent. And that's also something we see reinscribed throughout all of these different systems that we've been talking about, when maybe it's not about that. Maybe it's about the effect, how a person responds to what they're hearing. And some of your work illustrates this. So in a sense, I'm kind of saying back to the person who's giving me these thoughts on what she herself has written about. So I thank you for that, Jill, that I've learned from Ethical Loneliness a lot about the importance of hearing. But I do think that maybe one way of one avenue into that conversation is reframing in terms of, well, this isn't about your intent. But I think that that's something, as Western liberal subjectivity is so deeply grounded in that. And even on your work around critiquing social contract theory points this out. Christopher, I think you wanted to come in, and then we also have now a few more questions as well, which I'll get to after Christopher's comment.
Just on the question of intent, I think so. Some of the, again, to bring Charles Mills into the conversation. So one of the things Charles Mills distinction he makes is to say that not every white person is a signatory to the racial contract, but every white person is a beneficiary of the racial contract, right? So you don't have to actively ascribe to it. The tendency to focus on racism as intent is both a minimization of the structures of racialization and the structures of domination in favor of kind of an account for personal responsibility for bad use, and also shifts the focus onto the perpetrator. This is a CRT critique, right? That conversation that focuses on racism is a perpetrator-based conversation that seeks to redeem people out of their bad ideas. Whereas what's more interesting, and in some sense, relieving for those who are worried about getting caught out, is to say that the primary cause here, the distraction might be the utterance of racism, but it's the structure that we need to think about. It's the structure of white supremacy, politically, socially, morally. In some senses, and Claudia Rankine makes this point, that we focus on the individual. We scandalize the individual because it makes the rest of us, and I'm speaking as a white person here, feel like, well, we're the better whites, right? So we're not that individual, so we're not beneficiaries. Whereas Charles Mills would say, it's precisely the ability to say, this is how we should talk about racism as about racists, as opposed to racism as about structure, is a effect of my privilege as a white person. And I think that focus on the individual, that desire to focus on individual culpability, responsibility, aberration, is really interesting. And I think I said this at the outset, in terms of how it translates to much of the critiques made by Kamari and others, and yourself, Sarah, about that focus on international criminal law, that there's something that happens when you scandalize, or you focus on the individual, and you isolate individual political acts, and you absorb structures, right? That spectacularization or the scandalization of the racist is a similar move to the spectacularization or scandalization of the warlord in terms of what it does for the rest of us who are implicated in that system. So I think it's quite interesting to think about how that move operates across both critiques of thinking of race as racism, as opposed to race as what Charles Mills calls a socio-political system of white supremacy, and thinking of international justice as being about individual harm or individual responsibility, as opposed to international justice as a white system of white supremacy based on slavery, imperialism, and ongoing afterlives and political economy. So there's something, to me, there's something familiar in those moves to ascribe individual responsibility for both racism and war crimes that is both theoretically connected and, I would argue, historically connected. That the beneficiaries of both those ascriptions are the structures and the beneficiaries of white supremacy more generally, both the invisibilization of the structures of conflict, often linked to racial capitalism, and the invisibilization of white supremacy as a structure that we all benefit from as people racialized as white.
That's a really helpful way of moving between some of the critical work that's been done about the failures or limitations of the institutions and applying it to the institutional or the individual level, rather. Kamari, did you want to come in, or?
Yeah, I guess a small point, which is a big point, is very much in keeping with Jill and Christopher's reflections here. It's because often I go to the institutional, that's sort of my go-to place, and I'm appreciating the discussion of the individual, and it reminds me of a set of conversations that I've had with colleagues about weaponizing whiteness, so that those who are beneficiaries, using the language earlier, beneficiaries, or we might even talk about complicity, our complicity in structures of privilege, but that those who are beneficiaries have a responsibility to weaponize that whiteness against itself, or against white supremacy. What does that mean? How do we think about the weaponization of whiteness? In many ways, it has to do with the individual playing a role in not only acknowledging the way that they benefit from institutional structures that privilege who they are, how they look, and the kind of gains and access that they've had, but also the obligation to speak, to intervene, to do some of the messy work that might be more acceptable by colleagues rather than racialized people who come in and do that work. I mean, I think these are about the micro politics and how one engages in potentially radical work and what some of the strategies are when we work in institutions that can be difficult places to work. And so I think strategically there's a place for, just as there's a, in academia, there's a place for tenured faculty to speak up and take positions so as to protect others who are more vulnerable, who are going through promotions, etc. Just as those politics play out, certainly through the weaponization of status and security. In the same way, I really like this language of weaponizing. We also see this playing out. Some of my colleagues, Jafari Allen and others, talk about pigmentation. And in sort of the Black Atlantic world, light-skinned, dark-skinned, etc., and how those politics play out in relation to privilege. And we, and many are calling for the weaponization of lightness and whiteness. To do a different kind of work, and there in that conversation, it is about ethical responsibility. It's about recognizing the way that we're beneficiaries. So I like the direction of that discussion. I think it's generative, and in the end, there's no one answer, of course, and I think we all have to think about how we're positioned complexly. That whiteness doesn't always mean absolute privilege either, but it is part of an alliance with structural inequality. So I think it's generative and it's worth continued discussion, certainly. And I love that in this conversation today, we've been that race is front and center, racial, the racial nature of inequality isn't an appendage to the discussion of justice and inequality. It's actually fundamentally central to it. And I think that that's very useful. And these are the kind of discussions I think that we should be having in the sphere of international criminal law, that it's not invisibilized, that it is part of the ways that we think about the architecture of power. And so thank you of course to all of you for that and for making it part of the mainstream, right, in the ways that we're thinking through and pondering these questions.
Thank you so much, Kumari. And actually the next two questions, which I'll take together, are really focused on what is it that we are to do. And you had mentioned how to make radical interventions. And I think to some extent, both of these are posing questions about ethics. And so Felix Ndahinda is asking, should critical legal scholarship be activistic in ways of steering the debates you have been raising from theory to practice? And what are the dangers and benefits of that? And then Amisa Ramadani is asking, as a law student, I would like to know the mechanisms put in place to encourage people to unlearn as a way of solving the structural inequality issue. So the first question seems almost more pointed to what are our responses as scholars in our scholarly work. And then the second question is much more, what do we do as individuals to try to right some of these injustices? So I'm wondering if any of you three would like to respond to either of those questions.
They're good questions. I think they're very difficult. The work that I do is fairly theoretical. I think we all hopefully pick the lane that we're going to make the most difference in. And for me, it's thinking through philosophical difficulties and using real world evidence, testimony from people who have something to say that often doesn't get heard, to direct how I use theory or philosophy to talk about them, rather than bringing theory or philosophy to a scene and imposing it on it. And you could already say that has an activist bent to it, because I want to get people heard rather than just, making my philosophical point, regardless of what people on the ground might want. And I don't think that there are too many dangers about that. I think activism is something that we all should be engaged in. So I'm sure there might be dangers to it, but I'm not going to spend, maybe someone else can speak to that. But in terms of the second question of how we interrogate this idea of justice, for the law student wanting to know how to put in place mechanisms to encourage people to unlearn as a way of solving structural justice. I am trying to think my way through that right now. If you have ideas, send me an email. I feel like this is something we should all be working on together. What types, as someone who didn't go to law school, so therefore doesn't know what law school is like, I suppose I'm not the right person to answer it. All I can say is that in my own institution, we are trying to build a non-punitive restorative justice type of a mechanism for people reporting harms that normally don't have a place for report, like microaggressions in the classroom or other types of things like that, and hoping that that will make a difference. And I'll stop there so that there's space for others.
Thank you. I would just come in and say to Amissa, I think often when you're on the receiving end of being taught, there's a tendency to kind of underestimate your power of influencing the discussion. And so I think raising these kinds of questions put the people who are on the other side teaching you and the group who are interested in these kinds of issues in a situation where they kind of have to take it up. So I think I would just say that there's a considerable amount of untapped power of the students in the room in that scene.
So I put my cards on the table and say I don't think there's any redemption of international criminal law as a side of international justice. I think the tweet that we started with was me trying to sort of drop the mark on international criminal law as we understand it, to say that it's not just economically and morally, but that it lacks the symbolic economy or vocabulary, I should say, to reveal anything other, to produce anything resembling justice, that we need to substantially rethink international criminal law, international justice. And I think to take account into what we've learned over the last couple of years and to take into account the economic in a more fundamental way, not just to say international criminal law misses the economic, but to say, well, precisely how are those two systems articulated together? Not just to say there's examples of, as I have in the past, to say, well, there was this impunity that happened here, and then there was the system of imperialism established there, but to think more closely about what is an international justice that takes seriously both those mechanisms of international criminal law and international economic law and transnational movements of goods, commodities, and racialized identity. So that to some extent, it's to collapse those disciplines. If there is a future in international justice, it's to take, I think, the economic and racial capitalism in particular, in my work certainly, is something that I've been trying to think through over the last couple of years, and certainly since the pandemic, is to say that both as an intellectual and as someone who wants to get the waiver so my country can get vaccines, that international criminal law has run its course, right? That the intervention in that space needs to be fundamentally refashioned. And I'm not sure how it gets re-envisioned within the existing vocabulary, particularly because that vocabulary goes back to the abolition of slavery and the reinvention of slavery as white people saving others. I think that's a deeply held vocabulary of white saviorhood that I'm not sure can be redeemed symbolically. If it can institutionally, I'm all for that, but I have my doubts about whether there is an international criminal law that isn't always deeply invested in white supremacy. So the future for me would lie in trying to think across that and other types of fields, in particular through the concept of racial capitalism. It kind of brings together some of the critiques we've made with a more political economy account of the international.
Thank you, Christopher. And I'm aware of the time. We're now 2 hours in and we're meant to be ending shortly. And there's one final question, which I'm going to read out because I think you'll probably see that as I read this out, this is something that could start off another half hour of conversation because it's a very It's a rich question. So this is from Alphonse Malefu, who asks, can one relate justice with time? Because justice that is needed and possible today might not be what is appropriate tomorrow or yesterday. And he follows up, in other words, can justice be moderated? And I want to invite the three of you, if you have a rather short response to what is obviously a question that we could spend quite a long time on, to jump in, and then we will close.
I can quickly say that justice is always engaged with time. It's always adjudicating in a present moment something that happened in a past, hopefully for the sake of creating a future that isn't entirely determined by a past harm. That's a really simple way of looking at it, but I also think it's much more complex than that, that justice is also engaged in multiple temporalities at once. There's a cyclical kind of returning, kind of traumatic temporality where an injustice, even if it does get properly adjudicated, might not be fully solved and might return as a kind of a haunting or even just a continued way of life if other things aren't done to fix the larger harm. So this speaks back to what I was saying about how law doesn't get everything done, but just time ties into that. And I'll keep it short like that.
Thank you very much, Jill. And Kamari or Christopher, did you want to add any final words?
So, I mean, I'll say something, I'll end with an anecdote, because I like anecdotes. So an anecdote, the most radical thing that happened during the last year in international law was the African group at the Human Rights Council tried to get a resolution passed to deal with the question of racialized violence and racial injustice across the world. And of course, that was defeated or watered down in the final resolution. So that attempt to internationalize the fight against white supremacy is something that Malcolm X had asked the OAU to do in 1964. And in fact, if you go into the archives of the League of Nations, there's a petition from the Pan-African Congress in 1921 saying exactly that, that you need to have an international system that takes seriously the question of international justice. So the things that we need to do are already in the archive. We just don't exist in the future that archive imagined, right? So what we have to try to do, I think, is to shape the kind of future where the visions, the alternate imaginaries of Du Bois from 1921 or Malcolm X from 1964, that we're ready for that particular present. So I think in some senses, justice is fixed and we're the ones that move through time and come to terms with it.
Well, that's interesting. I don't even think I agree with you, Christopher, there, but it could be because I'm not following this where you came with the conclusion that justice is fixed, and because in fact I would argue that justice is itself a fiction, and when set aside or set alongside questions of temporality, we see how fluid it actually is, and that justice isn't the most useful rubric, that instead, if we think about the practices through which people achieve self-actualization, through economic possibility, through spiritual, emotional, political, etc., that people themselves determine what is just in whatever language or formulation that might be. And so, Christopher, I'm not sure if that's how that sets alongside what you ended with, but I think that we're talking about a fictive concept that is so slippery and does different kinds of work over time and continues to do so. But and so maybe, Christopher, if you could clarify, you said it sounds as if you're saying that there is a there with what justice is.
So I was being provocative. I was saying that justice, whatever that means, lies beyond the end of white supremacy, and that the international that will bring that to an end is already in an archive of a future that's past, right? So that in a sense, we need to prepare ourselves for the imaginations that come before us. And then at the end of the world of white supremacy, then whatever justice means will be constituted precisely in the way that you discuss it beyond that world, beyond the end of white world supremacy.
Oh, I love that. I mean, I think that's expansive, and the clarification is helpful. In fact, that's expansive, and it really reminds me of something that Angela Davis said once, which is that the moment that we fail to imagine a world anew, it's the moment that we've given up on our creativity. And so long as we think that the world that we're in its capitalist form is the only way to organize our world, with its prisons, with its forms of adjudication. It's the moment that we really are socially dead. So I love that way of really thinking of justice in those terms. So thanks for clarifying. Otherwise, we might have had a little battle there.
I think it's really unusual and great to be able to end on something that offers some sort of positive horizon. And I think we could have ended in a more pessimistic reading of the limits of international law, but I like very much that the discussion that wrapped things up points us in a new direction. And we probably have hours and hours more of this to discuss. But for now, I would just like to thank the panelists for your critical insights and suggestions and questions and the wonderful work that you're doing, as well as the audience for sitting through a 2-hour-long kind of discussion that had many different threads that still, I think, we could return to and continue for a long time. Thank you to the Center for Criminology and Socio-Legal Studies at the University of Toronto for hosting us, and to everyone for your participation. So there will be more discussions like this in the coming year. If you would like to know more about the Salon series or the summer school that is connected to it in Rwanda, please visit the website listed in the event description. And the theme for the next Salon is Instruments of Justice, and that will be held on the 3rd of December of this year. Thank you very much, and we look forward to having many of you join us in December.
Bye. Thank you, Sarah, for this.
Thank you, Sarah.
Thank you.
Thank you all.